Fake or a beat. Niggas quick to switch sides, don't be standing on shit.
You're rocking with the best.
They try to frame me with pictures I paint to cry and shame. But I won't let them change me. I'll remain forever remain.
Hey, they didn't think I would do it, but I did it. Really having this shit really winning. Was times that I thought I'd forever be sinning and spending whatever to stand on the business. But God bless the game, did it all but a sinning. All the shots they let off, but they ain't hitting. All the shots we let off, they ain't mentioned was hitting. Go ask why he's fighting them lips. Never change, I'm the same as you send me. The only thing changes the paper my V. Can't forget about the diamonds and chains on my pendant was starving, but now we each stay for a living. If we ever fell out, you was fake or a beat. Niggas quick to switch sides, don't be standing on shit. But yet I'm the biggest, ain't changing my clique. Rep to 6, disrespect and get put in that dick. I came up off for rapping, no prices for bricks. $1 million combos out to eat with my stick. Big got bows and condos, letting low go for 6. Brand new block with my little bro, shit came with a switch. In the list, how you niggas gon' die for that shit? Let them make it for months, hurt my pride a little bit. When they ride, make his whole family cry for that shit. I'm the same, I ain't letting shit sliding. I'm in every word that I said, I put this on the seat. I'm the same nigga thug from the cell to the bridge. Better ask you about X, matter of fact, come and see how this rap shit help with me, nothing to me. Hey.
I won't let them change me. I'll remain forever remain.
They say X when the change probably cause I got rich, I ain't hurting my kids, they ain't wanting for shit. They say X when the change probably came from a bitch tried to hit, now I'm up and they all on my dick. They say X when the change probably came from a nigga I fuck with, but good stand on 10 with the game. How come all of these folks get to say the X change? I'm the same and I'm standing on 10 with my name. Hey.
Too many pro se litigants enter court with viable arguments, then abandon them because those arguments don't promise total debt elimination. If a strategy won't erase the obligation, produce a payout, or unlock money from a securitization trust, they don't want it. The courtroom then becomes an extension of the debt elimination process, while solid issues involving evidence, procedure, controlling law, accounting, and available remedies get pushed aside. Tonight, we're exposing the danger of chasing money through lawsuits instead of pursuing relief a court can actually grant. This is not about surrendering valid defenses or accepting an unproven debt. It's about separating viable litigation strategy from financial fantasy. This is the new culture empire. Let's get into it.
Put a 30 to the semi and shoot.
You're rocking with the best.
It's gonna be a headshot, we aim at your medulla. I got all my jewelry on, so I ain't tryna be a brawler. So we gon' shoot like a hooper. Hop in the car, put it in turbo mode. I might do 200, I might do the whole dash. I might just crash it with, I ain't had to pay for it. I might just kill the club. Hop in the car, put it in turbo mode. I might do 200, I might do the whole dash. I might just crash it with, I ain't had to pay for it. I might just kill the club. Put it in turbo mode, I might do 200, I might do the whole dash, I might just crash it with, might have to pay for it, I might just kill the club, hop in the car, put it in turbo mode, I might do 200, I might do the whole dash, I might just crash it with, might have to pay for it, I might just kill the club. I'm on the stage, I'm lit, it's turned up, they see my eyes, I'm lit, I do it all the time, all my life on the line, shawty be acting real shy, she wanna show me, yeah, she wanna slide, hop in the back.
You're rocking with the best. You're rocking with the best. You're rocking with the best.
Well, I knew it was about to get here. I knew it was going to get here. Tonight, I want to address something that you've been following me for a while. You probably heard me talk about it plenty of times. And tonight, we have to address the pro se litigant trap regarding the debt elimination. And in this trap, viable claims, although they don't promise free and clear title off the break, although they don't promise 100% as soon as you file, you win. These claims, which will bring your lawsuit to the next stage, hell, keep you in the game, survive a motion to dismiss. And these claims are being abandoned. They're being abandoned because people want to chase the debt elimination arguments, which is nothing more than a debt elimination process, just bringing it into court. Many people are going to forego claims that otherwise would be viable, will be something the courts can track, but the claims are not expressly, with it gets to the relief requested, not a return of proceeds from the securitization trust, an invalidation of the debt, return the property interest back to the plaintiff or defendant free and clear. Since the claims are not initially in that nature, many people will disregard them and forego them just because the claims that they want to assert deals with debt elimination, free and clear title. This is one of the biggest mistakes made, and we're going to talk about it because I have a special report taken from the record that I want to get into, but I got to make sure I block out personal information before I do that. And it looks like we have it started. So this is the hidden ledger case study. Why the pro se space fails. One litigant, 4 arguments that work, 11 counts that bury them. So this was a case out of, I'll just say, Texas. Started in September last year. The plaintiff's name will remain anonymous, but they're appearing pro se as the executrix and the highest fiduciary of the trust, a private ministerial trust. The defendants are Serve Bank National Association, the Money Source Inc., represented by an attorney from Spencer Fain LLP. This regarding a mortgage case, a dispute. The documents were reviewed where plaintiffs, which is the borrowers, amended commercial tort claim, 11 counts, plaintiff's response in opposition to document number 45, and defendant's notice of servicing, transfer, and request for status conference filed March of this year, and the rest of the public document prepared by the Supreme Elite Team's litigation department. So I was going to read that all to you because I didn't want to show it to you. Protect the privacy a little bit. So I didn't want to show it to you, but we could start right here. We are live, Facebook, YouTube, and all that. Same old, same old. MD Imran, what's going on? What's going on? If y'all not getting the notifications, people hit me in the emails, haven't getting notifications. You might have to hit the notification bell, turn it off, turn it back on, and hit all notifications. The system has been slow. StreamYard sent me a notice that it's slow. It's a lot of traffic going, it's slow. So if you missed the stream, you probably have to catch the replay. Which they all do. Anyway. So this report is not about whether someone is smart enough or working hard enough or right about how they've been treated. This is a report about which arguments survive contact with a docket and which ones take everything else down with them. Yes, pro se people in these space do have legitimate arguments, but they get buried under arguments that are predicated off the debt relief process. Now, I'm just going to give you an example what a debt elimination process is. When someone says, hey, sign up for my auto discharge class, and you're going to get a course and documents to send to the finance company. Some of those documents are right to rescission, which has nothing to do with the auto transaction anyway. Notice rescission, notice of the highest honor in the land, and overall is basically a letter saying, I don't owe anymore because I found out that you did me so dirty. What along those lines? Anything that has to do with you sending a document that is predicated on as soon as you send it in, your debt is going to be eliminated. That is what I call the debt elimination process. Mortgages, credit cards, whatever. What you see in these spaces, I call it the debt elimination process. Why is that important? Because the debt elimination administrative processes are now spilling over into the courts with the filings that I continue to see on a daily basis. Now, number one, start here. This plaintiff, although in foreclosure, she is right about the most important thing. And this is what makes this so frustrating for me. And she knows who she is. Pretty sure she's going to watch this. She knows who she is. We are going to say the hard part later. We are saying this part first because it is true. Because it is the part that nobody has told her. And because everything after it depends on it being understood. My reports are very honest. They're very honest. If the numbers add up in this section, we're not going to act like they don't. They add up. But if they don't add up in another section, that's the part we attack. So if our claims have to be narrowed to that section, at least it's a viable claim. But as I said at the beginning, many people will disregard the 3 or 4 viable claims that they actually have and assert 12 different claims, because the 12 different claims in their mind, if they get them accepted, that means I keep the house, I don't have to pay for it anymore. And that's just not the reality of court. Let me give you a news flash. You want to know why these remedies, such as free and clear title to your property, want to know why they're so, these are the extraordinary remedies? and they're so hard to get every day. Wanna know why? Because you don't see from the docket, from the final orders. You don't see from the county record of deeds satisfactions being filed in the borrower's favors based on what you hear online every day. See, I don't go by what they tell you online. I go by the docket, the court records, because that's the data. What's been entered in the case, what's been filed, what's been recorded. That tells the true story. The docket tells the story. The county recorders tells the story. The release of lien filed with the county recorder adds way more than a person showing an email or a text message talking about, yay, we did it. We won. We got the house back. And posting that online. That doesn't tell me anything. Now, on the central procedural question in this case, the plaintiff is correct and the defendants are wrong. And this is a person's case. Like, I'm literally like, yo, you are actually right on these arguments. There are 4 points in her response in opposition that are supported by the rules, verifiable on the document, and will be taken seriously by any judge who read them in isolation. Section 1.1. A transfer of interest does not remove a party from a lawsuit. She was spot on with that. Document 45 of the record asserts that because the note and deed of trust were assigned to Lakeview Loan Servicing LLC on January of this year, Serve Bank and the money source are no longer the proper parties before the court. Well, this is what the Federal Rules of Civil Procedure, Section 25C says in full. Transfer of interest. If an interest is transferred, the action may be continued by or against the original party unless the court on motion orders the transferee to be substituted in the action or join with the original party. The rule says the opposite of what document 45 assumes. And although she didn't word it correctly, but she still made the point. So she gets the pro se, leeway with formalities. A mid-litigation transfer does not divest the court of jurisdiction, does not moot the claims, and does not excuse a party from a standing order. Substitution requires a motion and a court order. Document 45 is styled as a notice. See, she was arguing that, well, just because they substitute in mid-litigation, they shouldn't be able to do it. If she would have taken my advice, I would have narrowed it down to the rules and narrowed it down that a document is not a motion and a court order. Trapping them. But no. People think when I talk, I'm just trying to discredit what they're saying. And that may be true in different contexts. Now, it is not a motion under Rule 25C. And no order has substituted anyone. Her briefs makes this point at Part 2B of this report, and it is right. More fundamentally, claims that arose from conduct occurring while a party held the interest do not travel to the transferee. Whatever Serve Bank and the money source did between September 2025 and January 2026 is still theirs. It's still theirs. Shout out to TikTok. The initial disclosures problems is real and it is documented. Yes. And I'm not going to say your name live, but listen, ma'am, you have strong claims here. I've been pleading to you. You have some claims, but the claims that you tacked on later, it's going to destroy these claims. And you're going to lose your house behind these claims. Stick to the ones that you can prove that's viable. That's it. Even if they're not talking about you get the house free and clear right now. It's stages that you have to pass to get to that extraordinary argument. We got to dismantle everything they throw at us first before we remember. The longer the case goes on, the weaker their cases get. Lawyers are conditioned to front load the evidence of a case because they don't want it to get past a certain stage where when the courts are require more discovery to get into the substance of their claims, because it's going to fall apart. They all fall apart. They want to get it over with. This is why they're so aggressive in the beginning. This is why they always move for motion for summary judgment in the beginning, motion to dismiss in the beginning, because the longer the case goes on, if you make it to the discovery stage, in the corporate finance world, it is at the discovery stage where deals are made. It's at the discovery stage where settlements are made. It's at the discovery stage where they come back with a reduced principal balance. Hey, you owe us $350,000. We're gonna knock $200,000 off your principal balance. Just pay us $150,000. Here's the restructured payment terms. But in that moment, you have what I call leverage. If you don't have leverage over these people, they're going to steamroll over you in court. It's not about just your arguments and what you think is true. Your arguments have to create leverage over them. Trust me, take it for someone who's already been there and done that on the state and federal level. I've been there and done that, and I've seen it with my own eyes, the difference when you have leverage over them. Now, January 6th this year, the event, the initial pretrial conference, court identifies standing authority, Pete's status as a threshold issue. Source, document 45, January 7th, post-conference order, directing exchange of initial disclosures and an early summary judgment motion on those issues. January 13th, Serve Bank issued its notice of mortgage service and transfer to Loan Care on behalf of Lakeview, effective February 3rd. January 21st this year, defendants serve Rule 26A1 initial disclosures 8 days later, containing no reference to the transfer and identifying neither Loan Care or Lakeview. January 23rd this year, plaintiff files document 33, flagging the transfer, as she should. And if you ask me, yo, Ali, what's good? If you ask me, that was a legal and viable action. Kudos to her on that. January 27th, Serve Bank executes the assignment to Lakeview, recorded as at the county. Rule 26A1 requires disclosures of individuals and entities likely to have discoverable information. Rule 26E1 imposes a continuing duty to supplement Rule 37C1, supplies the consequences. I'm sorry. Rule 26E1 supplements a continuing duty to supplement. Rule 37C1 supplies the consequences. 8 days is not a close call. This is the strongest single argument in her entire file, and it takes one paragraph to make it. But since it's not talking about I keep my house free and clear, people are not going to hit on these arguments. I would have hammered these people on procedural arguments, because this is where the record is taking us. The record is moving us towards the procedural argument. When you keep slapping them in the face with procedural missteps and procedural violations, their case now, their credibility in their case now weakens. They're trying to cut corners. Hey, you're trying to cut corners, and the litigant trying to cut around the rules. What makes you think that you wasn't trying to cut corners with her? I mean, judges are human too. Hell, she been, you know, they've been catching with your hand in the cookie jar. What makes you think, hold on, let us take another look at her claims more seriously now. That's all it takes for a judge to start to take a pro se litigant seriously. When we heard the term in last hearing, I'm intending to agree with the defendants now. There's some confusion here. That right there was the words of, you are not getting the foreclosure judgment today. Hey, defense, I'm starting to agree with the defendants here. I'm starting to see where they're coming from. And that's all you need is the judge to take your claim serious. And then the new culture empire comes with the hammer. That's all it takes for them to take your claim serious. Now, section 1.3, the court order summary judgment motion was not filed. Document 32 ordered an early motion for summary judgment on the threshold issues by March 6, 2026. On February 25th of this year, the court denied the plaintiff's own pre-summary judgment motions as premature. They are making procedural errors. And you know what it goes to show? She's up against lawyers who are not very familiar and who doesn't have that much experience in federal court. She's going up against lawyers who don't have experience in federal courts, because I read the dockets and I found way more procedural errors where I would have crumbled them just by their mistakes in court before even getting to the substance of my claim. Because one thing, when you play around in federal courts, one thing you're going to know, and one thing of me sitting through my own federal trial, and one thing you're going to understand about federal courts, they are real strict on the rules and procedures. Ask the people in my group, every time I try to cut a corner, I got my hand caught in the cookie jar. They're not playing with the rules and procedures in federal court. They're not playing. Whether you're pro se or an attorney otherwise, they're not playing with you. They're not going to give you no leeway on the rules of procedure. Now, stating that those arguments belonged in her response to the forthcoming motion. On March 6, 2026, the defendants filed document 45 instead. No motion for summary judgment, no motion for extensions. That is a documented failure to comply with a standing order in the court's own Doc 44 established that the court expected the motion. I would have filed a motion for sanctions. Fuck it. We not okay. Put your arguments to the side right now. They just handed you another avenue that you didn't contemplate before court. Look at all their procedure violations. They're lawyers. This is motions for sanctions. Forget our arguments right now. Let's force the court to laser focus in on their continuous procedural missteps throughout this action. And I'm a pro se litigant, or you're a pro se litigant, and you've been following the rules the whole time. They haven't been following the rules. See, remember I say the nuance of court? This is now turned into another argument inside your arguments and another battle inside the overall war. You win the war in court by winning as many little battles, those in-between motions, those in-between filings, racking up as many preliminary wins as you can. That's how you win the overall case. The sad part is, in the pro se spaces, everybody thinks is, I file, keep my stuff, I win. I file and win. Not knowing, and I'm talking about if you actually been around long enough. These new rookie teachers that's just dealing with credit cards, they don't understand what I'm talking about. They haven't been through the fire. For the ones that everything I file is gold, every time I win, I file. Well, you don't really know how good you really are until you're in a heated battle, tested, and they're not just dismissing the case off the break. And now you got to have legal stamina and keep going and keeping up with court, creating new strategies as you go, being able to pivot on a dime, being able to shift, being able to look in the future. Look beyond the corner. See, anticipate their response and answering their anticipated response in your own brief before they even get a chance to raise it. Anticipating what they're going to say. Can you fill me up, man? Thank you. And it's not hard to anticipate. Take yourself from the inside of your case. When I mean inside, I mean it's your case. You know what you're doing. Take yourself from the inside of your case and look at your case and look at your filings from the outside looking in. What I'm saying is, as much as you are standing on your arguments, you are to scrutinize your arguments as well. You're supposed to look for holes in your own arguments, because the last thing you want to do in court is figure out you had holes in your argument for the first time is when the opposing party is discovering them. That's the last position you want to be in, realizing your arguments wasn't as strong as you was when the other side points them out. I'd rather me point them out to you before you file them. You don't want them to point it out first. Now, I'm telling you, she does not need a theory to make this point. She needs the docket, which she has. I'm telling you, she don't even, like, you could be scalping them on their procedural errors, but we get so caught up in our belief systems and the arguments that we want to make that we're just going to hone in, laser focus on just the arguments that we have in our head instead of being able to shift and adjust in mid litigation. We made prime example, last hearing, it was the evidentiary trial. We started out with a whole game plan. 30 minutes into the hearing, I told her to abandon the script, throw it to the side. We're going to freestyle the rest of this hearing because I see where it's going. And you have to be able to have that foresight to be able to abandon your initial script in court, in open court during a hearing, and develop your strategy on the fly. And that comes with court experience. It does. I wouldn't be able to teach anybody, a class or personal, how to do that. It's more instinct than anything. I can give you the things what to look for, but unless you're inside the courtroom, you don't really know how it's going to play out. Now, section 1.4, the successor's own letters do not agree with each other. In her response, February 18th, 19th this year, Loan Care sent 4 collection letters. They addressed it to her at an address she does not use. They stated 2 different amounts on the same day. $12,501.19 and then $12,676.19, a variance of exactly $175. And I didn't even do an audit on this and still found the numbers, the difference, the hidden figures. And one identified Fannie Mae as investor, where ServBank had previously identified Ginnie Mae. Oh my gosh. Like, they are handing her this dub. There's so much confusion with those people. The 2 different balances for the same debt on the same day from the same servicer is a misstatement of the amount of debt. 2 different investors is a misstatement of his character. For you consumer claims, I'm telling you, the litigation, the Supreme Elite Team's litigation department and the hidden figures in the ledger will hand wrap you consumer claims. It will hand wrap you those consumer claim peoples. It will, that you won't, the evidence you'll have against them when I find it, it will be far superior then you have to manufacture the violations. You know what I'm talking about? Because you got to write them and see if they violate something. Nah, their whole record is the violation. We're going to use what they already sent you as the violation. And this is what a lot of people, and they're going to start to do it now, because I am a trailblazer in this space. I am an innovator. I am a master motivator. We don't wait for them to make a mistake, because we just identify and alert the courts that they've already made the mistake. Everything that they put on the record is now evidence against them. Because I can tell you this from my personal contacts and people that I know, the numbers are never going to be 100% right. They're never going to be 100% accurate. But when you're claiming a balance due and a judgment due, that's what they have to be. But they will never be 100% accurate. Now, two different balances for the same debt on the same day from the same servicer is a misstatement of the amount of debt. Two different investors is a misstatement of his character. That is 15 USC 1692E and 1692G territory. And unlike everything else in this file, it is proved by putting the two letters next to each other. And what found in that in between lawsuit against them during this accountant claiming, it provides her leverage. See, if she would take my advice and stop thinking she could do everything by herself, I would actually build a legal strategy. See, my legal strategies are slow, methodical, meticulous, no wasted motions, no wasted pen and paper, no wasted moves, no wasted arguments. Every argument that raised, bam, it pierces through the heart of their claims. And it's not just one that does them in. It's an accumulation of body blows over the course of the fight. It's too many headshots throughout the course. It's not one single punch. It's the multitude that starts to, cutting the ring off on them, anticipating that counter. So when I throw that straight right-hand lead down the pike, I'm already pivoting out of the firing range. They swung, miss air. It's a lot more energy expense when you swing and miss versus swinging and connected. And just continue to box a methodical, pinpoint accuracy with every punch. Every punch makes sense. No wild haymakers. Know when to engage. Know when to back up. Conserving your energy along the way. Four arguments. Zero theory that's required. Like you could throw all those security, you could throw it out the window because you have four strong arguments that's built on just what they filed. Two different debts, amounts due, two different investors. What? That stick there, that taints everything they do left. You can't even find out who owns the debt. You don't even know. Do you know how sloppy that is? How much I would have exploited that? Hey, I got these 12 claims. Ma'am, you can flush those 12 claims down the toilet. These are our foundational claims right here. And anything that rise, we'll deal with it then. But this right here is going to get us back into right where we need to be and provide leverage. Zero argument, four arguments, zero theory requirement. Rule 25C, Rule 26E, a misorder, and $175 same-day variance. Four simple, bam, 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 bam. What is the problem with that, though? You want to know what the problem is? There's no debt elimination that's being referenced or attached to it. There's no free and clear title because of these right here. For these four arguments right here, it doesn't scream free and clear title. I'm telling you, they don't even understand that they're doing it. many people treat court as part of a debt element. They look at court as, I'm using the courts to not have to pay this debt anymore. I'm telling you, that is the worst angle to ever look at court. It is the worst angle. The odds of you getting free and clear title at any initial stage of the proceeding is 0 to none. I don't even use my own situation as a measuring stick to say, everybody that's behind me, you come to me, you're going to get the same outcome, because every facts and circumstance of each case is different. These teachers are not going to tell you that. There's a lot of things in your state laws is going to determine whether that's viable off the break or not. It's not me. Your state that you live in may be prohibiting that forfeiting of the remaining balance and free and clear debt. See, right there, your state determines whether that's viable or not me. But these social media gurus don't tell you, because they're not used to understanding court from multiple different jurisdictions. They understand court from an angle on which how they would do it. I look at everybody's court case based on its own facts and circumstances, and I adjust to that. There's no extra sprinkling in remedies in there if the record doesn't allow, if the rules don't allow, and if the procedural posture of the case, it will put you at a disadvantage. I will never file for a quiet title, and I know how to file those things very well, but I will never do it for you if your account is in the red, because you lose your standing to do so. We got to build up to that. You don't believe me? Just call my Florida client right now. It's in court. Talked about it the other night. So hold on. We need to, when we execute that, we need to have more leverage than what we have now. That's a strategic thing there. So let's just take the next hearing for where it goes. Just put the last hearing behind us. We got a small victory there, but it's time to go to work, because I'm anticipating them trying to come with the kitchen sink, and we have to be prepared. I know you're confident. I know you did good last hearing, but it's time to put the celebration for that to rest now, and let's get prepared for all-out war September 1st. If we don't have to go to war, cool, but I'm prepared that they're coming with every trick in the book. Rule 25C, Rule 26E, a misorder, 175 same-day variance. Every one of them is decided by a rule or a document. None of them requires a judge to accept a single contested premise about securitization, trust, QSIPs, or the nature of money. A 4-page brief making only these 4 points would be a serious filing that a court would have to answer. And I would have filed just that there and left it alone. For right now, no, we don't need to overdo. Forget the money. Throw the money, throw the securitization, throw it all out. We have a good procedural posture here, because everything is substantiated by their own action. So stop with the theories. Let's go with something we can actually prove. But that brief was never filed. What was filed instead is the subject of the rest of this report. And this is the part where it gets sad. This is the part where it gets frustrating with pro se litigants who think they know law, but they don't understand it. A quote from Judge Ruggiero J. Aldiser, winning on appeal in 1992. Yes, I follow the great lawyers of our time, landmark cases. I still haven't exposed the case that it's right along with a lot of these people with these NIs and instruments in these days. It's a landmark case. I was waiting. I may do it soon because no one has still never mentioned it. No one's never mentioned it. As a matter of fact, Supreme Elite Team University, I'm going to put that case in the chat so y'all can know that I know what I'm talking about. And I will read that case. And I want you to look across this landscape and see if anybody is citing that case. They didn't even know it exists. When it comes to case law research, let's just say there's no depths I won't go to find it. If it's out there, I'm going to find it. If there's a penny that's off, unaccounted for, I'm going to find it. You don't believe me? Ask No Caps. You don't believe me? Ask No Caps. When I read an appellate's brief that contains 10 or 12 points, a presumption arises that there is no merit to any of them. AKA, sometimes less is more with court. If you got 10 or 12 counts, 10 or 12 claims, you're already putting yourself at a disservice. You don't need 12, 13, 14 claims. You notice how my motion and limit for them coming up in court, it was narrowed down to 4 things. 4 things. In these spaces, you think you got to tack everything on because you don't want to miss something. Now, Section 2. And then it was buried. The 4 arguments above appear inside a response in opposition that also asks the court to consider the plaintiff's religious convictions, the ministerial purpose of a private trust, her military service, her 22 years of occupancy, First and 14th Amendment interference, and a challenge to whether opposing counsel has proven they were authorized to appear. Alongside it sits an amended commercial tort claim pleading 11 counts: fraud, fraudulent misrepresentation, fraudulent concealment, bad faith litigation conduct, unclean hands, torturous interference with commerce, breach of fiduciary duty, RESPA, FDCPA, DTPA, slander of title, and securitization fraud. That effectively killed her case. Killed the case. The 4 arguments that I identified, the record identified, that gave her a winning shot and gave her more credibility as it proceeded, that kills it right there. Yep. Take my advice. Just leave it there to those 4 claims right there so far. Those little pre-trial motions, those in-between motions to strike, force them to engage. You let them off the hook. And this is a representation of a lot of pro se litigants in this space. Y'all let these companies off the hook more than you prove their wrongdoings. The scary part is a lot of you don't even see that you're doing it. A judge does not grade each argument separately. A judge forms an impression of the filer and then reads everything else through it. Let me say that again. A judge does not grade each argument separately. A judge forms an impression of the filer and then reads everything else through it. That is not cynicism about judges. It is how reading works. Below is what the record does to the rest of it. Section 2.1, the CUSIP count. Count 11 is the centerpiece of the amended commercial tort claim. It alleges that an account number returns CUSIP number blank upon standard CUSIP lookup, that the CUSIP number identifies the Lord Abbott floating rate fund, and that this establishes or raises a compelling and well-founded inference that the note was securitized into that fund, Lord Abbott. It sounds like one of those fraudulent securitization audits that I went over a few weeks ago. That's what it sounds like. 100% of your securitization audits that y'all find or buy online is inadmissible in court. 100% of your securitization audits that you buy online from the securitization audit specialists, 100% of them are inadmissible in court. You want to know why? Because the courts, the CFPB, has called all securitization audits consumer fraud and consumer harm. None of it is accepted as evidence. Just because you don't like that I'm saying it doesn't make it less true. Because if you'd have did your research on the largest mortgage forensic companies that they had to pay back over $3 million to their consumers and been banned from the industry of practice, then you will realize that everything that's spawned since their ban practice is nothing but a variation of the same things that the CFPB, courts, and judges who cited them have called it consumer fraud. So do you think that you coming up with a securitization audit in court is going to be looked at as evidence? No. None of what's in the securitization audit is admissible in court because none of it passes the exception to the hearsay rule. You would get more. You will have more to work with just from a simple response to a debt validation or qualified written response. You'll get more out of that than the securitization audit because 100% of the funds that they say it's in is not legit. The servicer would tell you who owns the note. The servicer will provide you the pool number. The servicer would give you the identity. There's nothing about a securitization audit that even remotely hits to the substance of a foreclosure litigation. Nothing. And I've read hundreds of them. Nothing. I actually get more out of my own audits that I do. I provide people way more valuable information than a securitization audit. Because you want to know what's sprinkled inside of every securitization audit? Sovereign citizen claims that courts have been rejecting over the last 40 years. They won't tell you that. Let's get back to it. Now, the pleading asks the courts to take judicial notice under Federal Rules of Evidence 201. It's to find that the loan was securitized. The allegation: the mortgage account returns a CUSIP number. One thing I know her securitization audit was fraud because CUSIP numbers are not generated from mortgage accounts. CUSIP numbers are not generated from mortgage accounts. That's not even how it works. A CUSIP number just identifies a securities that travels through the secondary market. A mortgage account number never has a CUSIP number attached to it. That is factually incorrect. The record. A CUSIP is a 9-character identifier assigned to a registered security issue, a share class, a bond, an MBS pool. Individual residential mortgage loans are not assigned CUSIPs, and account numbers do not map to them. The lookup services that produce these results are sold to consumers. The output is not anything, is not a record of anything. The output is not a record of anything. So she's using the federal rules of evidence to ask the judge to take judicial notice of a fraudulent report, killing her case and her credibility right there. Everything that would have been built with those 4 legal arguments is now being dismantled by her. And these are the mistakes that many pro se litigants do every day. They don't realize what they call fraud, what they call conspiracy, what they call the judge that's not trying to hear them, what they call the systems out to get them. What they don't understand is 98% of adverse rulings, the pro se litigant did it to themselves in this space. But they can never, you know how hard it is to accept that I played a bigger role in me losing my house in this proceeding than anyone else, more than the lender, more than the other side, because they need someone to blame. But they will never blame themselves. Pro se litigants lose in court because they do it to themselves, whether through ignorance, whether through being hard-headed, whatever. Pro se litigants lose mainly because of them. CUSIP number blank identifies the Lord Abbott floating rate fund, an institutional fund holding the note. The Lord Abbott floating rate fund is an open-end mutual fund launched in 2007 that invests primarily in low and below investment grade floating rate corporate bank loans, leveraged loans to companies. It does not hold residential mortgage notes. And a fund share class CUSIP identifies shares of the fund, not any asset the fund owns. I told you, these audits are producing fraudulent, fictitious information because I did my research on the Lord Abbott floating rate fund. And it had nothing to do with a residential mortgage. The same one that goes for TikTok that's selling these securitization CUSIP numbers online for $200. When you get that little report back with the red arrow going to the top, yeah, you know what I'm talking about. Yeah, you know what I'm talking about. That. Go ahead and type that CUSIP number into a CUSIP lookup. I guarantee you the fund won't come back to anything that has to do with your actual transaction. Want to know why? Because I received almost 75 of them. Want to know why? Because when people reach out to me, they've already been down the rabbit hole. They've already purchased all that stuff. And you want to know why it's so popular? Because they don't give a damn about the CUSIP number. They give a damn about putting it on a tax return and getting $100 million refund from it. A refund that will never come. This is why they'll only show you the tax return stuff as it was filed with those CUSIPs. Notice how they make posts about what they just filed. But they'll never show you that the IRS cut a $378 million check because you will never enjoy it. If they erroneously issue a refund check for $378 million, they're immediately going to ask for it back. And if you don't give it back, they're going to escalate it and put you in prison. And I don't give a shit what you say, what anybody says online. None of them has anything for you when you're getting indicted by the government. None of these tactics online will work. And if you spent a dime of it, 2 convictions, that's very easy. Wire fraud and mail fraud. You use the mail to submit a fictitious instrument, bam. Uttering a fictitious obligation, 18 USC 514. You use the mail to mail the fictitious instrument to the IRS. Can't say that you didn't. And if you transfer any money to a different account, it's wire fraud. Easy to prove to the government. Why you think they always get it with wire fraud, mail fraud when they indict people for these fictitious, erroneous checks that they issue? And then when they ask for it back, they prosecute them when they don't send it back. And then in the indictment, it's always wire fraud, mail fraud. Too easy to prove, guaranteeing several years in federal prison. See, it's all fun and games and theories, and it's all kumbaya till you're getting indicted. And then everybody crumbles. No, nobody stands on their talking points when the feds come and indict them. You know what happens? Everybody's telling on the teacher. Oh, well, me, I got it from them. Here's the class. See, they'll come online and defend the teacher against me. But if their teacher's teaching got them indicted, they're going to turn on that teacher fast because now self-preservation kicks in. Oh, man, I'm too real for these spaces. Why they don't like me? I'm too real for these spaces. I be speaking of things that people know is true deep down inside. They just don't want to admit. The greedy people, they know they're motivated by greed. The desperate people, they know they're motivated by desperation. I know. Defendants concealed the identity of the loan's owner in violation of 15 USC 1641 F2. Her own pleadings state that on August 25th of last year, Sur Bank identified Guinea Man as an investor and again transferred the note, deed of trust, and closing docs on September 8th and on the 19th. Section 1641 F2 requires the servicer to identify the owner or master servicer. The pleading concedes the disclosure it alleges was withheld. Get it? August 25th, Sarah Bank identified Guinea May. So her own pleading concedes that the disclosure was made, that she said was withheld. Because you admitted that they said it's Guinea May. The argument, one of the 4 I was talking about, was 2 different owners at the same time. Big inconsistencies. Now, Your Honor, we need to look at this more. According to their own letters to me, I don't know who to pay. What's going on? Hold on, you got 2 different owners of one loan. You don't think that will raise material claims in court? No, because those claims, you know what's not hooked up to those claims? Free and clear title. Want to know why? Because people treat courts as an extension of the debt elimination administrative process. Another allegation. The court should judicially notice the securitization under Federal Rules of Evidence 201. Rule 201 reaches facts not subject to reasonable dispute. A court can notice that a CUSIP identifies a particular fund. It cannot notice that this borrower's note is inside it. The inference is the entire account. And it precisely what Rule 201 does not do. I told you the interpretation of the statutes pro se litigants read, the rules they cite, the case law they cite, they don't understand the art of proper interpretation. They don't, you don't understand it. They don't understand the art of accurate interpretation. They don't understand it. This is I think it says this. I'm going to use my belief and throw, what did I always say? They use their belief system first and then throw a statute or a rule or a regulation as a ribbon on top of it. One more feature that deserves attention. 1 second. One more feature of this count that deserves attention. The amended commercial tort claim carries a verification. I declare under penalty of perjury pursuant to 28 U.S.C. 1746 that the foregoing and all factual allegations contained therein are true and correct. The accusive allegations is pleaded as facts, not as beliefs, and it is sworn. That's a dangerous slope there. The two cases she cites decides against her. What do I always say in these spaces? Many of the case law pro se litigants cite are always cases that goes against them rather than supports their arguments. At part 2C of her response, plaintiff cites Renegel and Martins, the two leading Fifth Circuit decisions in this area, for the proposition that where a note has been securitized, whether anyone in the servicing chain suffered a concrete injury is not abstract, it is dispositive. So let's do it again. Authority she cites, Martin Burst BAC Home Loan Servicer LP, Fifth Circuit 2013. What it actually holds. Texas does not recognize show me the note. And I covered this early June in one of my lives. The note and deed of trust lien are separate obligations affording distinct remedies. This is what many pro se litigants don't want to hear because it goes against their arguments. The mortgage servicers need not hold or own the note and yet will be authorized to administer a foreclosure. Remember when I said I have a copy of their private agreements that's not made public, which authorizes the servicer to foreclose on behalf of the investor in the trust to initiate it. See, I only got that because I'm connected to people that worked at the highest level of the SEC. That's the only reason why I got it. I didn't get that on my own research. So many people don't even understand what's really going on. See, the curtain was pulled back for me. And I pulled that curtain back for my group. So a lot of y'all are just oblivious to what's really going on regardless. That's just what it is. This is why claims over here are so different, because we got more inside intel to add to it that the average pro se litigant just doesn't know exists. But it's okay. You got to work with what you have. All that matters, therefore, is that the mortgage be properly assigned. Reginald versus Deutsche Bank, 5th Circuit 2013. A borrower may challenge an assignment only if the defect will render it void, not merely voidable. An assignment made in violation of a pooling and service agreement, including a transfer after the trust closing date, is voidable at most, and the borrower lacks standing to raise it. Remember the 25 years, the past 30 years of the court, when I went over in my newsletter, the status of these courts over the last 30 years in a report that I put out with hella case citations. See, between 2007 and 2011, these arguments were more accepted. In 2012, your late remit transfer, your securitization, defects in assignments, defects in the chain of title, those defects that people still want to raise today. Guess what? You have no standing to raise the defect. And let's just say that you did. It makes the loan voidable, not void, meaning the trustee can cure the defects at the request of the actual participants of the mortgage pool. But none of that gives a borrower any right to challenge an assignment from the issuing entity into the trust, because you're not a beneficial holder of the participations issued by the issuing entity. I know people like Debt Society want to tell you you're an investor. See, that sounds good online to a defaulted borrower trying to keep their house. That sounds good. But when it gets to the real world, the corporate finance world, are you registered on the books as an investor? Do you get monthly updates? Are you a part of their quarterly investor meetings? Are you getting a link? Are you getting principal and interest payments monthly? Are you? On your own mortgage that you're allegedly an investor in? Are you? If the answer to those questions are no, and you know the answer is a no, you're not an investor. You want to know why I know this? My uncle is an investor. He buys mortgage-backed securities. I've seen his chart on his computer. I've seen. And ain't no borrower is getting what I seen him get. Y'all don't get it. So you're not an investor. You can't raise it. And even if you were an investor, you're not going to stop your principal interest payments. You're just going to tell them to fix the issue. They're going to fix the issue and bam. But you're never going to be like, nah, cancel the mortgage, cancel the note, the borrow. No, because you've already made your investment. You want your return. So you wouldn't even do that anyway if you're an investor. So once again, it goes back to what I've been saying. A lot of these arguments on social media sounds good and it's inspiring to people who's in a rut. It's very inspiring, but it means nothing in court, which means people that's desperate to save their homes in court, by raising these arguments, they're accelerating the loss of their home more than they're doing to delay it. And just because you don't like how it sounds, how I'm delivering it to you, doesn't mean that what I'm saying is not valid. Let's go. These are not obscure cases. They are the two decisions opposing counsel will cite, citing them affirmatively in a brief for a proposition they reject is the kind of error from which a filer does not recover in a judge's estimation. Three other citations in the file do not carry the weight placed on them. Navarro Savers Association versus Lee, 1980, is cited for equity jurisdiction under Article 3 as invoked by plaintiff's trust capacity. It is a diversity jurisdiction case about whether trustees are real parties in interest, and it says nothing of the kind. Carpenter versus Longan, another one of these Carpenter cases that you normally hear in sovereign citizen spaces. This is where I started to believe, and I know for a fact that her case started to turn into sovereign citizen arguments, because raising sovereign citizen arguments while still rejecting the name of a sovereign citizen roughly is about 98.9% of pro se litigants. They will reject the name, reject the status, but their documents all still have the hallmarks. Carpenter versus Logan, 83 U.S. 271, 1872, correctly holds that the mortgage follows the note. It is then deployed to argue that an assignment of the deed of trust conveys nothing, which Martins forecloses in Texas. And Steel Company versus Citizens for a Better Environment, U.S. Supreme Court 1998, is cited for the rule that standing is measured at the commencement of the suit. A rule that in this case points at the plaintiffs own capacity to sue because she's coming in as the trustee. So if I was the opposing attorney, I would say, hold on, Your Honor. She lacks standing to bring this complaint because she says she's the trustee. And there's case law that trustees cannot sue in their own capacity. So right there, her case could be dismissed because of that. If the lawyers are on point, see what she's opened herself up to? There is not, from what I've read, there is not a pro se complaint that I've read that if I was the opposing party, I couldn't destroy. I couldn't destroy. I will rip 95% of these pro se arguments to shred if I was the opposing attorney. To shred. Let me give you a good saying from Martin's versus BAC Home Loan Servicing, 5th Circuit, 2013. The mortgage servicer need not hold or own the note and yet will be authorized to administer a foreclosure. All that matters, therefore, is that the mortgage be properly assigned. And ladies and gentlemen, that's what they do because they have private agreements that are not disclosed in their SEC filings. It's between the servicer and the investors. You will never see that agreement online. Trust me. It's not in no SEC filing. It's not. I told you the only way I was able to get it because I know somebody, I know somebody, I know somebody, I know something about it. So I'm telling you, those arguments are dead on arrival. Oh yeah. It's not uncommon to read people's cases and they got two good arguments and the rest will kill the two good arguments. Number 3, the problem that gets decided before any of it. There is an issue in this file that a court can resolve without reaching a single argument of either side, and it's not on anyone's list. The plaintiff sues as executrix and highest fiduciary of the trust, a private ministerial trust. Her response states that the trust has been the legal title holder of record since July 9, 2025. The federal docket carries the case under that caption. This is the problem that she runs in. A non-lawyer cannot litigate on behalf of a trust. 28 U.S.C. Section 1654 permits parties to plead and conduct their own cases personally or by counsel. The Supreme Court has held that it has been the law for the better part of 2 centuries that an artificial entity may appear in federal court only through licensed counsel. Rowland versus California's Men's Colony, 1993. The 5th Circuit applies the rule to individuals attempting to represent others. Menon versus Allied WQSR, 5th Circuit, 2004. A trustee who was not the sole beneficiary cannot prosecute a trust claims pro se, where the trust is the record title holder and the claims are the trust. The pleading is filed by someone who was not permitted to file it, regardless of how strong the Rule 25C argument inside it may be. This is the single most dangerous fact in the file, and it was created by the plaintiff in July 2025, 3 weeks before the events she is suing about. What do I say? 100% self-inflicted wounds, aka pro se litigants. The sentence that cost the most from the amended commercial tort claim, Part 4A, verbatim, from plaintiff's own pleading. Prior to July 2025, plaintiff maintained a perfect payment history on the alleged mortgage obligation right there. And this is the part that saddens me. This is the part that saddens me. You was paying on time for damn near 20 years. You was paying on time. Then you get caught in these social media spaces. When I first met you, you wasn't doing this. But these social media spaces, these executress, that Davis Clarence, that Kirk's method, these are destroying people's lives. But y'all want to defend this shit. Well, the court and the court, but you know but they can't do this and they can't do. It's unconstitutional. Shut up, because you're not saving people's homes. And you can't even save your own self. Shut up. On July 15, 2025, plaintiff issued a served bank CFO a notice of discharge and set off of debt obligation, sovereign citizen correspondences. It was only after this administrative action and plaintiff's subsequent formal demand for debt validation that defendants began issuing correspondence declaring the loan in default. No. And this is the part that they don't want to tell themselves. They think that just because the loan was discharged and set off, that by them demanding payment is retaliatory. And reality is, the loan was in default because you stopped paying. Listen, I know they want to erase that from their head because if they acknowledge it, then means that they themselves caused this to happen. So they got to say, oh, they only asking for payment because it's retaliatory to what I said and they really can't get around it. That's what they all say. But if you ask them, did you stop paying under the contract that you agreed to pay? You're going to get gaslighting. You're going to get the goalposts moved. And it's going to be like pulling teeth from my 4-year-old's mouth for them to give a straight, honest answer. You may be 30 minutes into the conversation before they actually answer the question honestly. The pleading, but hold on, just think about what I'm saying. And think about the facts of my unprecedented case. I spent 16 months investigating them. Over thousands and thousands and thousands of pages of documents read. 8, 9, 10, 12 hours. Well over thousands of hours. Then I finally filed my lawsuit August last year. January, they make an appearance. January 22nd, they made an appearance. No, January 23rd, they made an appearance. After speaking to me on the phone first, the lawyer. January 23rd, they agreed to my terms. January 28th, stipulation dismissal. January 30th, balance went to 0. February 3rd, title in the mail. Achieved the debt elimination that many people seek all day, every day. Got the property without having to pay for it. Almost $20,000 they walked away from. But the most important part wasn't the outcome. The most important part was the preparation for that outcome. The most important part was the 16 months. Because it was the 16 months that set the ball rolling for those outcomes. Hell, the end part was nothing. I didn't have to go back and forth with them. As soon as they made an appearance, bam, next day, they agreed to my terms. They didn't even make an appearance, so they talked to me first. And they agreed to everything. Hell, I even wanted language changed to match what I wanted, and they agreed to everything. So what I'm saying is the preparation in these spaces suck. People are not prepared for court the way they should be. It's the preparation that brings the results, not so much of the arguments that you're raising. Now, the pleadings offer this as proof that the default was retaliatory. The judge reads the same sentence and sees a borrower who was current, sent a self-executing discharge, and then stopped paying. That is what the courts see. So that notice of discharge is set off of debt obligation. It means nothing. The retaliation theory requires the court to accept that the July 15 notice discharged the debt. It did not. See, this is the part when I think her mindset she got bit by the sovereign citizen bug. It is a very contagious bug. Federal courts in Texas have uniformly rejected private paper of this kind as a method of extinguishing obligation. And they have noted that a litigant cannot claim to be sovereign, independent of government authority, while simultaneously asking the judicial system to grant them recourse. Woo-wee! God almighty. Federal courts are not playing with anyone. I'm a pro se in New York and California. Uploading my first video today. Yeah, if you want to, if you want to get your video, you go get promotion on your own channel. Ain't no promotion over here. And from the looks of things, you upload your first video today, you pro se, but you ain't been around long enough. Everybody thinks that they can just be, everybody think it be pro se and handle the court. You ain't got enough experience. You ain't got enough experience. A lot of pro se litigants, you don't do good because you don't have enough experience in court. You got to learn by getting your head smacked around. That's how you learn how to navigate through courts, by getting your head smacked around. You don't learn by being bubble wrapped in court. You're going to suffer your defeats too. That's how you learn through your defeats. You don't learn by maintaining a 100% win record. There's no 100% win records. I know they don't want to talk about it in these spaces, but you don't win them all. I win every single case. Well, how many cases you got? One. Oh, duh. Been around courts 5, 6, 7 years, or be around courts about 20, 21, 22 and a half, about 22 years like me. You're going to see a lot of shit. No, not studying courts. Inside it. 22 years. Federal trial and state trial. On a federal level and state level. Arguing my own motions in front of a federal judge. Going back and forth with the government. Fought the government tooth and nail. Fought them to the end. You ain't no more battle tested, being battle tested by the federal government. While having your motions granted over the government's objection. Having your appeal accepted over the government's objection after you waive your right to appeal. You ain't battle tested unless you stood toe-to-toe to the federal government. That's the real battle there. Every subsequent count depends on that sequence. The fraud counts, the retaliation narrative, and the torturous interference count, the breach of fiduciary count, all of them are built on the premise that the default was manufactured. The record says the default followed the notice. Every single assertion is built off that premise. The vocabulary is evidence. We raise this without any interest in belief systems because courts do not have interest in that either. They have a pattern recognition interest. And the following terms appear across these filings: private ministerial trust, highest fiduciary, impropria persona, sui juris, notice of discharge is set off, notice of dishonor and opportunity to cure, certificate of non-response, commercial tort claim, a punctuated surname, built-in equity. Commercial, what do those titles scream? Tell me what those titles scream. They all scream sovereign citizen. Hey, I'm much more calmer and nicer in real life when you talk to me on the phone. I'm way more calmer in real life. They have a commercial tort claim is worth isolating. It is defined in term in UCC Article 9, a category of collateral in which a security interest may be taken. It is not a cause of action, and there is no such federal pleading. So all you commercial tort claim people, you filing that means nothing. But why do you file it? Because they told you it was something to file that you saw on the paper. Under Federal Rules of Civil Procedure, Section 15, subsection A2, an amended complaint at this stage requires the opposing party's written consent or leave of court. Under Rule 24, adding parties require a court order, a document that incorporates, quote, incorporates and supersedes all prior tort claims and adds 11 counts and 2 defendants is an amendment, and it needs leave. You see, you see how I pay attention to the details in court rules, court procedures, how court works. These are the things that the average pro se litigant in this space will fly right over top of their head. Wouldn't even know that they're violating the rule, right? It'll do this. Fly right over top of their head. They don't even, because they don't have enough experience of court rules and procedure. How technical it is. How everything regarding court is governed by a rule which governs the proceedings. She didn't even understand that there was a rule governing that. See? And these are the little mistakes that sinks pro se cases all day. We all know the big mistakes. But what's more damaging in these spaces are the little mistakes that you don't see. The little mistakes that you don't anticipate. The little mistakes that you don't catch before you send it out. And the first time you even contemplate that it be a mistake is when the other side is catching it. That's the last people that you want to catch your mistakes, is the other side. You rather a person like me catch the mistakes before you, because we can do corrective measures. But nah, y'all want to file it as is because you think you know more about it. Because many people, they know very little about a system that they think they understand. So they think they got it down pat in order to get their head smacked to the white meat by the other side. And now it gets to the conspiracy, or they're just trying to block. No, you're wrong. And that's another thing about pro se spaces. Very few will admit when they just got it wrong. None of this vocabulary changes what the docket shows about Rule 26, but it determines how carefully the judge reads the paragraph where Rule 26 appears. 4, answering the question she just raised. The plaintiff has recently reported new findings, an altered note, a CUSIP, a pooling and service agreement, a trust with Wells Fargo as trustee that closed March 30th, 2015, an undated allonge from the money source, a chain running People's Banks to Serve Bank to Loan Care with no money source in it, and a Texas law requiring a governmental owner to be recorded. Each deserves a direct answer. You know what the problem is? Many pro se litigants read statutes, case law, rules from their own interpretation, meaning they just read the statute and they think the statute says what it says. And in many cases, the statute is saying what it says. And that's still not enough. I'm going to say it again. Statutes, case law, rules, regulations are all a matter of interpretation. You could be reading a statute right word for word, but the interpretation of that statute is what determines whether you cited it correctly or not. Meaning, our interpretations of a statute means diddly jack shit. I never interpret a statute based on how I see it. It's impossible. Hey, new culture, how do you interpret this statute? Hold on. Okay, you got all these courts. They said that. They said that. They've consistently said this statute means this. The state Supreme Court settled it there. The appellate court has pretty much said the same thing because they can't say nothing different for the Supreme Court. The lower court said the same thing. I interpret the statute this way. What's your reason for interpreting the statute this way? Because all the courts have said it means this. No, I want your interpretation. No. My interpretation doesn't matter, sir. So what's your interpretation of the statute? Whatever their interpretation of the statute is. No, I want your no, my opinion doesn't matter. So you mean your interpretation of the statute was directly what the courts interpret? Yep, that's my interpretation. So whatever the courts are consistently saying what the statute means, that's how you, yep, that's how I'm interpreting it. No, I want your personal, no. I'm not going to give you my personal interpretation. It doesn't matter. Well, I think the statute says this. Okay, hold that thought. Okay, the courts have consistently said it means different. Your interpretation is wrong. Why? Because the courts have consistently interpreted differently. See? So I don't have an opinion about this. You will never hear me interpret. When you hear me interpret the statute online, you best believe I done did my research. I have courts have consistently interpreted. That's my interpretation. I don't have a personal interpretation. I don't teach from a personal interpretation of a statute. That's what these social media teachers do. Now, they may start changing it now that I said something. I mean, a lot of them change their position after I speak on it. Ask Yusavelle. He got half his followers mad at him now. Yusavelle is parroting me. He might as well be the new culture 2.0. Look at Title 12 USC Section 412. Notice how I made the people drop that like a bad habit. They don't even talk about it no more, do they? When last time you hear, and I ain't talking about people that I don't know, but when last time you hear 12 USC 412 really been floating around? Nope. All it takes is for the Supreme Elite team to speak on it, and people shoo, drop it. That's because we are the trailblazers. We are the innovators. We are the motivators. We are the inspirators. And I am the blueprint. Plaintiff has recently reported new filings and all that, right? Now, here's the finding and the answer on the law and the record. Here's her finding. The note they are passing around has been altered. Quote, that's quote from her pleadings. Now, this is the strongest item on the list and the only one we're pursuing. Texas Business and Commercial Code 3.407 govern. And that's the saying, she didn't even cite that. So I went a step further for her. Governs alterations of a negotiable instrument, and a fraudulent alteration by one person entitled to enforce can discharge the obligation. It requires three things: her executed closing copy, the copy produced in litigation, and a document difference between them. Then inspection of the original under Federal Rules of Civil Procedure, Section 34A1A. This is a document comparison, not a theory. Second one, the trust closed 3/30/2015, and my note never made it into the trust. That's foreclosed by Renegal. A transfer to a securitization trust after its closing date renders the assignment voidable and not void, and a borrower has no standing to raise it. This is the part where 5 or 6 more gurus are going to come into my DMs trying to argue me how what they teach is right, and I never solicit them to have the conversation with me. Every time I speak on something that is a selling point for these teachers, they always come to my DM trying to argue me about what they're teaching are right, and I don't even know who the hell they are. Want to know why? Because you don't see them inside here. But I always catch them in my DMs after the live. If TikTok could ever have a feature that shows who's on the outside watching, oh man, I guarantee you see about 70, 80 people. And if the note is not in the trust is simply irrelevant. That establishes nothing about who may enforce. But that is a hot selling point in a mortgage securitization defense online. And they don't like it because I use case law and cases that have already been decided on these issues before these teachers became teachers. They don't like the fact that I'm showing them cases from 2013, 14, 15, before they even thought about teaching mortgage defense. So everything they're teaching has already been foreclosed at minimum 10 years before they started teaching. Woo! Another assertion: there has never been a payee named. An endorsement in blank is not a defect. Texas Business and Commercial Code 3.205B, an instrument endorsed in blank becomes payable to bearer and may be negotiated by transfer of possession alone. Under 3.301, the holder of a bearer paper is a person entitled to force it. A blank endorsement is the ordinary statutory authorized way. Note smooth. Prime example, you get your paycheck back in the day, about 2004, 2005, when paper checks was still good. You take it to your bank. What's the first thing your banks ask you to do? Sign the back of it. Why? Because as soon as you sign the back of it, it converted into bearer paper, meaning although your name was on the page to the order, they could still negotiate the check because you just converted the instrument into a bearer paper, meaning not only you can cash it, anybody in possession can cash it, and that's why banks have you sign the back of it, because that allows them to cash it. See, that's real life. See, we could use real life. We could use real life Y'all see what I'm saying? Then you be like, I know you thinking like, damn, that is, yeah, you right, damn. Damn, I did, yeah. I could track that. Yeah, I did sign the back of that motherfucker though. And when I was young, I didn't know why I did it. They just said did it. Yeah. I did sign the back of the check before. Yeah. I had the paper, told when to cash it. They turned it over, said sign the back of it. Yeah, I remember picking up the pen and signing the back of it. Yeah, okay. New coach, I feel you. Yeah. I got you. I'm tracking. I know you are. I know. It's not hard. It's not a hard concept. An Elan signed by VP of the money source, no date. That's her assertion. Under Texas Business Code 3.2048, an endorsement may be written on a paper affixed to the instrument. There is no dating requirement. An undated endorsement is not evidence of anything. You see, they don't. She is a classic example of what I mean. I'm taking her words and then applying the law to it. So far, everything she's asserting, it's not supported in law or fact. These are beliefs. But her house is on the line. So these little mistakes, misstatements are going to cost her more because that stakes are higher. This is something that I would have understood if she just had a mock trial, mock draft, mock pleading where she's just trying to learn and get better. She's making these mistakes while her most valuable asset is on the line. The paper trail shows People's Bank to Serve Bank to Loan Care only, no money source. Two different chains are being compared. Endorsements track the notes. Service and transfer notices and recorded assignments track servicing in the lien. You see how that nuance, that little nuancy distinction? Because she is dealing with someone who's been around this shit for decades. So I'm always looking for the nuances. I'm looking for the little things, the little in-between things that for some people in these spaces, you have to put it on a microscope to see it, or magnifying glass to see it. I'm always looking for the little hairs, the little lip balls on the shirt. I'm looking for the little things that many people, since they're so small, they overlook it. I look for the little teeny things first. Then I move to the big stuff. Because it's the little things that lose your case like this. It's the little things that lose your case. It's never the big things that lose your case. It's the little missteps, that little misinterpretations, the little things. An undated endorsement is not evidence of anything. Another thing, the paper trail shows People's Bank to Serve Bank to loan. Oh, we already did that. I got you. Two different chains are being compared. Endorsements track the note. Service and transfer notices and recorded assignments track servicing in the lien. A servicer she paid for 8 years will not appear in the endorsement chain unless it also held the note. The absence is expected. It's not anomalous. Another one. A Texas law says a governing entity claiming ownership must be listed and recorded in the county. When I saw that a Texas law says, without saying Texas Business and Commercial Code 2.2.344 says, this is a belief. No such statute exists. Texas laws runs the other way. Texas Property Code 51.0001 subsection 4 defines mortgage to include the grantee, beneficiary, owner, or holder of a security instrument, a book entry system, or a mortgage servicer. And section 51.0025 expressly authorizes a mortgage servicer to administer a foreclosure on the mortgagee's behalf. Texas does not require the owner of a note be identified in the real property records. Ginnie Mae is not listed anywhere. Consistent with how Ginnie Mae works, Ginnie Mae guarantees mortgage-backed securities. It does not ordinarily own individual loans, and the issuer retains the note in servicing. Ginnie Mae as investor on a servicing screen is an expected entry, not a concealed one. My loan isn't even recognized on the lender's books. See, with that, this is one of the part that frustrates me, because I deal with advanced accounting. I actually read and dissect balance sheets as part of my specialty. I can literally find where between 190 million and 250 million dollars have been misclassified. I literally dissect balance sheets as part of my specialty. So it frustrates me when I hear these vague terms of ledger, books, double bookkeeping entries, assets, liabilities, the debits and the credits. Those are terms used by people who don't really understand what accounting for these highly complex securitization transactions are about. So they fill in the void with these vague terms. Prime example. I don't even know where is that. Okay, right here. My loan is not even recognized on the lender's books, and none of them will provide a verified statement under penalty of perjury. That term right there, under penalty of perjury, is a sovereign citizen request. No statute obligates a servicer to swear a statement on demand. Told you. That's a sovereign citizen, patriot, redemption, Moorish American thing they just put together. No statute obligates a servicer to swear a statement on demand. The mechanisms that do compel sworn testimonies are Federal Rules Civil Procedures 30, subsection B6, depositions, and Rule 33, interrogatories under oath, and Rule 56, affidavits. A refusal to volunteer an affidavit is not evidence. An unanswered Rule 30 subsection B6 notice is. The little things. Everything here are the little things. Everything here, if she would accept my advice, none of this would have been present. None of it. But when people are so far gone and the underlying issue is they're in desperation mode to save their homes, they don't want to hear anything beyond affirmation, confirmation. Yeah, sis, you gonna get them. That's all they want to hear. They don't want to hear critique, because the pressures of the thought of might losing their home starts to build. So this report, I'm just going to send it to her and let it be. But I'm pretty sure the response is going to be some justification to why she's right, when the record is saying something totally different. And that is that is prevalent in pro se sovereign citizen spaces. They can never be wrong. They can never be wrong. Notice what happened. Of the 8 findings, 7 are answered by statute or a Fifth Circuit case in one sentence. The 8th, the altered note, is real, is checkable. It has been sitting underneath the other 7. So the altered note's been passing around. The one viable claim with tracks 5 total have been buried under 10 that's going to overshadow her legal claims. Sometimes less is more. If she would have left it off with the 4 legal claims and add that note, alter notice the 5th, stop there. Nope. In these spaces, you throw everything at the wall and hope something sticks. No legal professional attorney will ever take that approach. But lawyers don't know what they're doing. Y'all know way more than the lawyers. They've been spanking this space for 30 years. But nah, the lawyers don't know nothing. Abraham Lincoln, notes for a lawyer lecture. This was his notes. 1850. Discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. When I had the opportunity to settle, when they agreed to it, that was the end of my litigation. Want to know why? Because there's no point. I already proved my point. Now I'm going for the judgment. No. See, you know what else is missing in this space? Discipline. Many pro se litigants don't have discipline, restraint. They don't understand what that means. But you know what helped them understand what it means? Being in court and around court for about 10, 15, 20 years. You start to get seasoned at this. This is what her case right here. This ain't nothing, second nature to me. Because I've read hundreds and hundreds of these same cases and I've seen it too many times. 5, the tail. If the claim does not erase the debt, it does not get filed. Here we go. The tail. If the claim does not erase the debt, it does not get filed. This is why a lot of pro se litigants have a problem with my approach. Because my approach is not 100%. We filing this to eliminate the debt. Right. Everything in parts 1 through 4 points are one conclusion. And it's not about this plaintiff. It is about the market she is standing in. The new culture empire has been saying it for years. This space treats courts as an extension of the debt elimination process and chases money through lawsuits. This file is the cleanest proof of it we have seen. Run the test yourself on the 11 counts in the amended commercial tort claim. Sort them not by whether they are strong and not by whether they are supported. Sort them by what happens to the mortgage if the counts succeed. What the claims will produce. The debt goes away. Quiet title, void assignments, securitization fraud, no person to entitled to enforce, discharge is set off, slander of title, cloud on the title. The claims, counts 2, 4, 10, 11. In July 15, 25, notice of discharge that precedes it all. Pleaded at length, sworn, and briefed across 2 documents. What the claim will produce. A rule is enforced and the case proceeds. Rule 25C, defendant stay in. Rule 26E, 37C, disclosure sanctions. Remember I said file a motion and sanctions. Non-compliance with document 32, Rule 19, joiner of successors. The claims not pleaded as claims at all. They appear as scattered paragraphs inside a 22-page response. Pleaded, present, but unweaponized. Her strongest. Strong. Which would have led her down that path to the result she's looking for. Because many people don't understand. I told you, when you come to court with debt elimination mindset, you have that 30, 45 to 60-day time frame that you think the case is supposed to be dismissed or thrown out. Very few people plan for the next year or two in court. I do. That's why I don't throw all the darts, because I know this can drag on for a minute. It's called legal stamina. Money in known amounts, FDCPA 1692E, 1692G, for two balances on the same day in two different investors. Statutory damages, $1,000 per defendant plus actual damages and fees under 1692K, RESPA 2605F, and DTPA, economic damages. The claims recited generically in counts 8 and 9. The one fact that proves them, the $175 same day variance, is described in a response and never tied to the count. Was it pleaded? It was recited, not pleaded. You notice how everything that quiet title, void assignment that will make the debt go away, she pleaded it at length. But all the claims, the Rule 25C, Rule 26E, Rule 37C, disclosure sanctions, non-compliance, Rule 19 joinder, wasn't pleaded at all. And the real counts that where the money she could have got, some statutory damages, recited but not pleaded at all. You want to know why? Because outside the ones that she pleaded, she don't see an elimination of a debt in those pleadings. Her mindset of filing this lawsuit is debt elimination. And that mindset is what kills a lot of pro se litigants' arguments in court. The mindset behind the arguments. This is a selection function laid bare. The claims that would erase the obligation were developed, verified under penalty of perjury, and given their own 11-count pleading. The claims that will actually win something were left as loose paragraphs. Nobody chose the second category because a Rule 26 sanction and a $1,000 statutory recovery are not a house.
You're rocking with the best.
AKA, if it ain't about a house free and clear, they will forego their strongest arguments. They treat court as an extension of the debt elimination process. 5.1, these arguments are not decided. They are decided. The single most expensive misunderstanding in this space is the belief that securitization and chain of title theories are novel, unexplored, or suppressed. They are none of those things. They are litigated to conclusion in the very circuit this case sits in, and the conclusions are public. The theory, they cannot foreclose unless they produce the original note. Martins versus BAC home loaners. Texas does not recognize show me the note. The note and the lien are separate obligations. The mortgage servicer need not hold or own the note and yet will be authorized to administer a foreclosure. All that matters, therefore, is that the mortgage be properly assigned. The same circuit ruled that, in which she's now bringing that claim in, aka dead on arrival. What's the percentage rate in these spaces? 98. The note was never properly transferred to the trust, so the assignment is void. Remember when I said 99% of mortgage defense arguments, all their defense comes from the 2007 to 2012 foreclosure crisis in the response to the mortgage bubble and the recession. Those early claims that lawyers were making, that is what you see today. The average mortgage defense person is utilizing the same 08 recession tactics that have been foreclosed by every court in America today. Yeah. Renegade versus Deutsche Bank, Fifth Circuit, 2013. Why is it 2013? Remember I said 2007 to 2012? Because when 2013 came around, all those early 08 recession outcry for the mortgage bubble, the arguments that they were raising in the beginning was completely shut down by 2013. So by their own definition, by their own logic, many mortgage defense teachers online are arguing 13-year outdated arguments that every appellate court in America has already decided against. So, but when you take that 08 recession bubble, securitization, fraud arguments away from this space, what do you actually have? You have nothing in rare except
they studying the source now. Supreme Elite. New Empire Talk.
you don't ever. And this is why when you can't figure someone out, you stay away from them. I done read y'all motions that I've been filing in court. You ain't seen that nobody raise what I raise. Articulate it the way I articulate it. Break it down the way I break it down. And then show you how it plays out in live court. Now, a buyer may attack an assignment only where the defect renders it void. A transfer that violates a pooling and service agreement, including one made after the trust closing date, is voidable at most, and the borrower lacks standing to raise it. So basically, there's no arguments that they're raising that makes the mortgage loan void. The late assignment to the remit beyond 90 days, wasn't properly assigned. Those are voidable arguments. It doesn't stop the underlying debt. Another one, the theory. The deed of trust is split for the note, so the lien is unenforceable. This is the same social media regurgitated arguments. Farkas versus GMAC Mortgage LLC, Fifth Circuit, 2013. Following Martins, the split note theory has been rejected in Texas. And they hate the fact that it's not my opinion. All these mortgage defense teachers, I can find case law in their own state or their own client state that's utterly rejecting what they're teaching online. MERS cannot assign anything. Rejected. Texas Property Code 510014 defines mortgage to include a book entry system, aka MERS. See, these are the things that I would have told her if she just would have accepted my help, accepted my advice. Bam, MERS is part of a book entry system. You're not going to win that argument. And a mortgage servicer, 51.0025, authorizes the servicer to administer a foreclosure on the mortgagee's behalf. Another one, my private administrative notice discharged the obligation. That pretty much goes without saying, but federal courts in Texas have uniformly rejected privately created paper as a method of extinguishing a debt and have observed that a litigant cannot claim to be sovereign and independent of government authority while simultaneously asking a judicial system for recourse. Why do they do that? 5 theories, 5 published answers. None of this is hitting. It is the first thing opposing counsel pulls, and it is free. Anyone selling these arguments either has not read the circuit they are selling into or has read it and is selling anyway. The literature says the quiet part out loud. The academic treatment of this substance is not coy about what is driving it. The Yale Law Journal published a comment titled, "Without Irony, in Defense of Free Houses," which takes as its starting premise that courts confronting defective foreclosures are visibly reluctant to bar future enforcement. That is, are afraid of handing borrowers a free house, and that this reluctance shapes outcomes across the field. The article argues courts should be less afraid. Annie, what matters here is that the framing is uncontested on both sides. Everyone in the discussions knows what the theories are for. If the scholarship defending the outcome calls it a free house, a district judge reading an 11-count commercial claim is not going to call it anything else. The hell is wrong with you people? You actually think you about to get a free house out these people? You really think so? You really think life is like that? You think these people don't want their money back? You will want your money back too if you loan someone $500,000 and get a house. You know you want your money back too. What is wrong with? And this is the part where it separates the new coaching empire and the Supreme League team from everybody else, because we can still look at reality and still produce viable claims. This is why we win way more than we lose. 20-1 record for 2026. 20-1. 20-1. I love those odds. What win percentage is that? Because ain't nobody this year won 20. Ain't nobody collectively between myself and my group members. 20. We win way more than we lose. And we embrace the dubs the same way we accept the L's. We understand when the argument won't get us nowhere, and we understand when we have a viable claim. We have discipline over here. Because unlike these gurus, I'm a real teacher. And I've been fact-checked by top professional litigants. So excuse the confidence. The institutions that regulate this market call it a scheme. What the federal agencies actually publish. The FBI has issued repeated warnings about mortgage elimination schemes in which the promoter convinces a home buyer that a debt is invalid or enforceable because of alleged technicalities in the loan documents, frequently using a trust, a demand letter, and a purported reconveyance of title. It has prosecuted the promoters. The Consumer Financial Protection Bureau, I know they always love this, the cite the CFPB, but they never want to quote the CFPB when they're discredited and putting alerts out about the same process that their gurus are selling them. The students love to go to the CFPB, but they never want to search the CFPB when they're speaking about their teacher. The CFPB, in its published guidance on spotting foreclosure relief scams, lists as a leading red flag any operation that tells you to stop making your mortgage payments. Uh-oh, new coaching empire. That is 99.99% of these teachers. They always tell you to stop. The Federal Trade Commission and the Federal Housing Finance Agency maintaining standing consumer adversaries on the same conduct. The documented result for the consumer, in the agency's own words, default, damaged credit, litigation action, and loss of the property. Read that last line against the record in this case. A bar with, by her own sworn account, a perfect payment history. Survey notice a discharge is set off on July 15, 2025. She is now in default, in litigation, facing arrears, and carrying 2 recorded assignments, she says clouds her title. The theory did not defend the house, The theory is what put the house at risk. What the securitization argument actually buys. Suppose every securitization allegation in this file were true. Suppose the note is in a pool. The trust closed in 2015, and no defendant ever held the paper. Under Martins and Regal, the borrower still owes the money. The lien is still enforceable, and the servicer may still administer and foreclose. The best possible outcome of the best possible version of the theory is a paragraph in an order, and the note remains payable to whoever holds it. That's it. That's it, in order. The note still remains payable to whoever owes it. And then the true holder is going to come out the cloud and demand payment and start the whole process over. If people knew that the securitization argument does not give them a free house since they're in default, they would abandon the argument tomorrow. They'll drop it tomorrow. You won't even hear them talk about it no more. Because every argument in this space always has to do with getting out of a debt, aka the debt elimination process. The theory that promises everything delivers a paragraph. The rules that promise almost nothing delivers the case.
You're rocking with the best.
The theory that promises everything just delivers a paragraph. Just talk. The rules, court rules that promise almost nothing deliver the case. These arguments here may get you closer to the goal that you seek, but since those arguments wasn't directly attached to a free house, she abandoned them. That inversion is the whole business model of this space, and it is why it fails. The price of admission. None of this is free to attempt. Federal Rule Civil Procedure 11B applies by its terms to an unrepresented party, and Rule 11C permits sanctions on the court's own initiative. Federal courts retain inherent authority to sanction bad faith conduct. Chambers v. NASCO, Inc., 1991. And the Fifth Circuit has said plainly that one acting pro se has no license to harass others, clog the judicial machinery with meritless litigation, and abuse already overloaded court documents. Ferguson versus H. Bank, Houston, N.A. Pre-filing injunctions against vexatious litigants, issues on that basis. A pleading verified under 28 U.S.C. 1746 containing a factual allegation that can be disproved by reading a mutual fund perspectives is the kind of filing that begins that conversation. The theory does not merely fail, it creates exposures that the borrower did not have before she filed it. Told you, pro se space, pro se litigants, an overwhelmingly majority of them do more to accelerate the loss of their house than they do to keep it. One acting pro se has no license to harass other, cause the judicial machinery with meritless litigations, and abuse already overloaded documents. Ferguson versus H.M. Bank, Houston, N.A., Fifth Circuit, 1986. Many people wouldn't want to get a report from me because they wouldn't, especially if they already had their complaint ready to go. But yo, let me pay you for the run the report. I don't think many people would like what the report would find, because we pick your complaint apart letter for letter and match it with case law, match it with the rules, and match it with the courts have already decided. So why does this space fail? Not for a lack of intelligence and not for a lack of effort. The plaintiff has produced more work product in 6 months than most represented parties generate in a year. The failure is structural, and it has 4 parts. I told you, the structuring of complaints, the structuring of your arguments mean more than the arguments that you raise. How you word arguments matters. Volume is solid as strength. 11 counts feels like 11 chances. It is not. It is 11 opportunities for the defendants to pick the weakest one and answer to that one at length. The 4 rule-based arguments in this file would have been very difficult to answer. Surrounded by 7 that are not, they never have to be reached. The other side don't even got to argue. It's brought to the first 4, and it is not uncommon for a pro se litigant to reach out to me or any other person in the space with things that's on the record already that's going to have accelerate the loss of their home, and then have it just makes the whole thing fucked up because they're not going to respond to the new viable claims now. They're going to hone in on what they already put on the record by trying to do this themselves. Many pro se litigants fuck up by trying to do it themselves because they don't understand court. They don't understand court rules, and their initial filings are all based on what they learned online. The secrets are sold as leverage. CUSIP lookups, wet ink note demands, gap accounting demands, discharge notices, trust conveyances. Each is marketed as the thing the banks do not want you to know. Each is marketed as the things the banks don't want you to know. But each has been litigated to conclusion. And the conclusion is in reported decisions. Nothing in this category is secret. It is settled against the person raising it. The banks don't want you to know this. The banks don't want you to know this. This is what nobody's going to tell you. The banks don't want you to know this. Man, somebody already raised those same arguments about 15 years before you started teaching it. So what do you guys say about this case right here? Hold on. Is that what you said? All right, let me read this part. And this is when to go, well, yeah, that person probably ain't do something right or the stat. No. It's because you're just reciting what you heard, and now you're teaching it to make a quick buck. So you haven't thought case law applies to these arguments. You thought these are arguments that you're making in the private against you and the bank. Right. Nobody runs the disqualifying test first. Nobody runs the disqualifying test first. Remember when I said, you said something to me, I'm going to look at it like I'm the opposing counsel, and I'm going to find holes in your stuff. Same thing I do in my own stuff. I look at some, I seen something today. I was making an argument. I said, hold on, let me reverse this. I said, ooh, they could get away by saying that. Let me narrow the argument down so it excludes the weak parts and only focus on the strong parts. They never run their own test on themselves. Is type it and file it. I believe this is an argument. Go file it. Before advancing a theory, someone should try to kill it. This is where I come in at.
You're rocking with the best.
Where I come in at. This is where I come in at. If you think you have strong court arguments, send it to me. If it passes my inspection, I guarantee the odds of it passing, I'm telling you. It's a team that's behind me. Not just my own words. I can take it a step further than me and get a professional eyes on it. Top professional lawyer on it. If it passes us, the committee, you have viable claims. Before advancing a theory, someone should try to kill it. Find the controlling case, read it, and see whether it survives. Had that been done here, Martins and Renego would have removed the securitization theory in an afternoon. The four surviving arguments would have been obvious because they would have been all that was left. The arguments that I suggest. The penalty is asymmetric. A represented defendant who files a bad paper gets a response and moves on. In this case, the defendants blew a court-ordered deadline and filed a notice that misstates Rule 25.6, and it will cost them very little. A pro se litigant who files a bad paper acquires a reputation that attaches to every subsequent filing. What do you mean you only get one shot with the courts? To make a good impression, new culture, they allow you to amend your complaints. Right. I still remember that question. Yeah, but the damage is already done with the first one they dismissed. So they allow you as a formality, but they're not going to take your amended complaints any seriously. Want to know why? Because they're going to be reading all your amended complaints through the lens of the first one they dismissed. It's over with. Man, I don't like that because I just filed my amended complaint today. He trying to say, like, I ain't going to win. Let me get out of this live. I don't like what he said. Let me leave. You leaving doesn't make you win your case. You leaving doesn't mean you're going to win your case. The reality still stands. You ain't going to win your case because you leave. You don't like what I'm saying. No, I mean, you're going to win. That is unfair. It is also exactly what happens, and pretending otherwise is what the space sells. The exposure nobody mentions. Federal Civil Procedure 11B applies to, by its terms, to an unrepresented party rule. 11C permits sanctions on the court's own initiative. Beyond the rules, federal courts have inherent powers to sanction bad faith conduct. Cited in her own brief and available in both directions, in the Fifth Circuit has been explicit that one acting pro se has no license to harass others, clog the courts and the judicial machinery with meritless litigations, and abuse already overloaded court documents. Pre-filing injunctions against vexatious litigants are entered on this basis. A sworn pleading containing a factual allegation that can be disproved by reading a fund perspective. It's the kind of filing that starts that conversation by funding perspective. What the 4-page version looks like. We are not going to draft it here. We're going to describe it because the description is the whole lesson. It opposes document 45 and nothing else. It quotes Rule 25C and observes that document 45 is not in motion. It sets out the January 13th, January 21st sequence and cites Rule 26A, 1A, I, 26E1, 37C1. It notes that document 32 ordered a motion by March 6 and document 44 confirmed the court expected it, and no motion and no extension request was filed. It attaches the 4 loan care letters and points at the $12,501.19 next to the $12,676.19 on the same day, and at Fannie Mae next to Ginnie Mae. It asks for 3 things: that the defendant remains parties, that Lakeview Loan Care be joined under Rule 19, and that the court set a status conference the defendants themselves requested it. It says nothing about QSIPs, trusts, ministerial purposes, wet ink, gap, discharge, or the nature of money. The things I just cited is what 99% what you hear and they teach online. Sorry, not because those things don't matter to the person filing, because a brief is not where a person is heard. It's where a rule is applied. The strongest document in this file is 4 pages long. It has never been written. Everything needed to write it, it's already in the record. Self-inflicting wounds, aka pro se litigants. Pro se litigants, aka synonymous to the term self-inflicting wounds. but always want to come online and blame somebody else. Blame the fraud, blame the card. Check yourself before you want to start checking everybody else. Because maybe it's you that's doing the fraud and the harm. No, it can't be me. I can't do nothing wrong. I can't afford for it to be me. I need this debt elimination. I need this house free and clear. I'm behind on my payments too long. I can't pay it back. Now I don't want to pay it back because I've been ingrained with it. I don't got to pay nothing back. I got to keep the blinders on. I got to leave anybody's life who's not giving me hope. Right. It's the mindset behind these pro se litigants more than anything else. It's the mindset. They don't have the mindset for this. They're too emotionally involved. They're too emotionally attached. And they can't see outside of a debt elimination. That's all they see with their arguments. Shout out to Law for Living. Shout out to Law for Living. It's all they see. Step outside the debt reality, y'all. These people not about to hand you a free house because of technical violation. They're not going to hand you a free house because some document, the chain of custody wasn't properly done or the assignment was late. You're not about to get a free house for that. Those are technical things, and many times you don't even have the standing to raise it because you're not even a participant. You're not an investor. Her strongest arguments wasn't even filed, wasn't even contemplated, and it's sitting right there on a silver platter for her because, like I always say, she could have just used their own words and their own letters and their own filings against them. And you wonder why I yell and rant. And you wonder why, when I look at the 50,000 court judgments, 20,000 foreclosures a week, and y'all just let them off the hook. Y'all let them off the hook every time. So trying to advance your online argument so much, you're not even looking at the full picture. Like, hold on. I know I got these arguments here, but hold on. They done fucked up on the record. This is something that's instantly provable. I got theories over here I want to advance. This right here is supported by the record itself. Now, let me hold on. I know I was typing this up. I'll save that for later. We put that to the side. Let me go with something right now that's already provable by their own words, their own admissions, but they already filed. Once again, all she had to do, oppose document 45 and nothing else, quotes Rule 25C, and observe that document 45 is not a motion. Sets out that the January 13th through 21 sequence cites Rule 26A1, big A, I, 26E1, 37C1, and notes that document 32 ordered a motion by March 6. That document 44 confirmed the court expected it, and that no motion and no extension request was filed. It attaches the 4 loan care letters and points at the $12,501.19 next to the $12,676.19 on the same day, and that Fannie Mae next to Ginnie Mae. So you got 2 different loan care amounts, 2 different investors, Fannie Mae and Ginnie Mae, and it asked the court for 3 things: that the defendants remain parties, that Lakeview and Loan Care can be joined under Rule 19, and that the court set the status conference the defendants themselves requested. Puts them right under the fucking gun. Explain the 2 different balances, explain the 2 different owners at the same time. Those arguments would advance your agenda of getting the house free and clear more than this 11 commercial tort claim claps. Commercial tort commercial tort claim counts that collapsed it, your 4 viable arguments. So now these arguments that I would have told her to stick with, they're dead down the drain now, because now the defense got all these arguments that you raised that the courts have already rejected. Self-inflicting wounds. And one thing worth investigating: if the note produced in this litigation differs from her executed closing copy, that is a 3.47 question, Texas code, and it's worth every hour it takes. It is proved by laying 2 documents side by side and expecting the original under Rule 34. It does not require a securitization theory, and this is the point: a securitization theory makes it harder to be heard, not easier. Judge Leonard Hand addresses the Association of the Bar of the City of New York, 1921. As a litigant, I should dread a lawsuit beyond almost anything else short of sickness and death. It's brutal in court, y'all. It's brutal. It gets so nuancey, so technical. You got to watch out for so many twists and turns. You got to make sure that the statute that you cite in the courts interpret it the same way. And this is the part that in my newsletter the other day, how courts are fundamentally changing the statutes, the court rules, the regulations, the laws by doctrines. AKA, say it a different way, they're changing the statutes, the rules, the regulations by their interpretations. It's the interpretation of the statute that could fundamentally change it. Prime example: statutory violations of the FDCPA. A court ruling has now changed that. What's the court ruling? Citing a statutory violation, which is what the statute says. Here's the caveat that changes it: without proof of a real world concrete injury, it's not stated claim. They just changed the statutory meaning of the FDCPA claims. Now you got to prove real world injury, real world harm, meaning they robo-calling you outside of calling you 500,000 times, waking you up out of your sleep, harassing you every day. That's not a real world injury. You see how they just push the standard out further? And that's what courts do. It used to be, hey, if you're going to introduce business records, you better know the software. You better have personal knowledge. You damn near had to be there when it was made. The rulings that came out that changed all across the United States, oh, you don't need personal knowledge anymore. You don't need to know the software. Now, they don't need that for it to be entered. They just have to have knowledge of it. They just got to know about the system and say, hey, yeah, we use this in the ordinary course of business. That's what changed it. So the rules of evidence 803 in these states equivalent has now just changed. And this is how the courts change the laws without ever touching a letter to the statute, because court interpretations, when the lower courts, appellates on down, are consistent in their interpretations, it keeps the Supreme Court out the picture. The Supreme Court steps in when there's a split among too many circuits. These circuits are seeing it this way. These circuits are seeing this way. Supreme Court will take the case to settle the score. But as long as the lower courts, appellate on down, are consistent in their interpretations, they're shielding us from the Supreme Court's interpretation. Thus, they are changing the way the game is being played through changing their interpretation of the law. Yeah, and I can't lie. That's an angle that many people don't even like look at. Like, wanna know why? because it was told to me by a professional that's been doing this for 30-something years. Verbatim, that's how the game goes. That's how the game goes. I already told y'all that every time the Supreme Court issues a ruling that the governments don't like, they just make an amendment to the Constitution. Two things that they done it. 14th Amendment and 16th Amendment. They didn't like the Supreme Court's ruling in the Dred Scott case. What did they do? They passed the 14th Amendment. Who was it principally aimed for? African Americans. Now it extends to everybody today that's born and naturalized in the United States, but the original intent of the 14th Amendment was for African Americans, slaves. The Pollock case of 1874, invalidated income taxes are unconstitutional based on a certain clause. The way that they argued that case, the government didn't like it. What did they do? Here goes the 16th Amendment. So Congress uses amendments they have used amendments to the Constitution to bypass a Supreme Court ruling that they don't like. And anytime the Supreme Court makes a ruling that Congress hates, there's going to be another amendment to the Constitution or another law that's passed. And that is how the game goes. It's how the game is played. An argument, a understanding of a case law today, which is favorable as today, may be favorable to us tomorrow if a opinion comes out that changes the game. A favorable ruling for us is never set in stone. It can change any day with a new precedent. The business records that was favorable to us changed. Now it's favorable to them. So trying to argue against the admission of the records, it is a losing battle. Like getting admitted into evidence from the jump, it's a losing battle because the threshold is so low. Do you know how many times I've seen people try to prevent those records from being admitted, and the judge just admits them under there? So when I see the landscape, when I see the shift, guess what I do? I adapt to the shift. So I don't try to argue against the records being admitted. I'll go by what the controlling case said is still what they have to prove, and I attack that. This is why the audit report is so important, because it hits to everything that the business records rules says that they still have to do. That's what it hits on. Matter of fact, no caps. You in the building. You read the audit. You in here. You read the audit. You can let everybody know about the audit. Very honest, very real, very accurate, very, 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 very realistic. Down to the penny. Why we publish this one? We do not usually write about another litigant's file. I usually don't do that. But we are writing about this one because it is the clearest example we have seen of the central failures of this space. A person who is right about something important loses anyway because of what she attached to it. He said, yeah, I'm going over it right now. Yeah. Oh, yeah. Oh, yeah. The hidden figures, the hidden numbers. If there is a penny that's off, I'm going to find it. Tell your finance companies, make sure they got it right the first time. If there's a penny that's off, I'm going to find it. Why we publish this one here? The 4 parts in part 1 are hers. She found them, she documented them, and she is correct about all 4. They are sitting inside 2 documents that a court is likely to read with an impression already formed. An impression formed by a sworn CUSIP allegation, an 11-count commercial tort claim filed without leave, a trust that cannot appear pro se, and a discharge notice that preceded the default. This is the whole thesis of this newsletter. It's stated plainly as we know, in this arena, you are not judged on your best argument. You are judged on your worst one. And then your best one is read through it. AKA, you only get 1 shot to make a good impression. Supreme Elite Team Litigation Department. Thomas Legacy 603@gmail.com. Sources for this edition. The public file assigned to the district judge. Of course, the defendant's notice of service and transfer request for status conference. Of course, all the plaintiff stuff. The tort claim. Every case and statute discussed was retrieved and read. Every quotation is from the field document or the reported decision. No figure, date, docket number, or holder in this decision was supplied by anything other than the record. Part 5 additionally draws on Martins versus BAC Home Loan Services, Renegale versus Deutsche Bank, Farkas versus GMAC Mortgage, Chambers versus NASCO Inc., Farguson versus N-Bank, Texas Property Code 510001, 51.0025, the Yale Journal, comment in defense of free houses, and published consumer warnings from the Federal Bureau of Investigations, the Consumer Financial Protection Bureau, the Federal Trade Commission, and the Federal Housing Agencies. This is what comprises of my newsletters. And all these newsletters, and if person ones like this in the redacted versions, will be available through on the Patreon in its own separate tier. And we'll be putting out newsletters once a week. We'll be putting out newsletters once a week. And yeah, to keep you, if anything, to keep you informed, because this is something that I think people should start getting into it. They start getting into it. Be honest with you. Hey, so, all right, hold on, let me see, make sure that. All right, so, without it too personal, they gonna know this. So look, bro. So a late charge stated at twice what the note permits. So this is what you have going in your favor. As late charge stated twice what the note permits. $837.44, broski. Exhibit E records each late charge as a single assessment. $52.34 assessment. Displayed on 2 mirrored lines, code LCA and code UI, uncollected items. Exhibit F, the loan history produced by their counsel, records the identical event in its other column as $104.68. Flagged L for late charges, exactly twice the amount. This is not an isolated posted. It occurs on every late charge event in the overlapping period without exception. $52.34. That's 5% of the $1,046.88 scheduled P&I payment per note, Section 6A. $104.68, twice the contractual maximum. 16 events. Total assessment window, $837.44. Total of the $1,674.88. The variance amount, $837.44 they charged you outside of what the note allows. 100%. Before the note arrived, this was a conflict between two servicers' records with no way to say which was right. The note resolves it, and Section 6 fixes a charge at 5% of the overdue principal and interest and provides that the borrower will pay it promptly, but only once on each late payment. $1,046.88 times 5%, that's $52.34. The Exhibit E figure is the contractual figure. The Exhibit F figure is twice the maximum the instrument permits. In the words only once foreclosed, the only reading that would justify it. No caps, you just got a bomb of an enhancement to your complaint. Now that's all I'm gonna read, because that was a paid for thing. And when you no caps, when you go down, bro, you got $661.26 collected outside the principal, interest, and escrow. Now, where would this extra $661.26 come from if it wasn't the principal, interest, and escrow? Remember when I keep talking about those side agreements that they had? And that none of those agreements, you can trace it back to the notes authorization. I don't give a damn what your case is. I don't give a damn what your situation is. It's always going to have charges that are not authorized, and I can trace its source back. But I got to trace the source back in a roundabout way. Because if I put it in your face again to you, be like, oh, that's confidentiality. You ain't supposed to have that. Where you get that from? And it could damage your case. So the way I do it now is, now that I know the source, I make them explain the source for you. So you don't got to say it. Make them say it. Where'd this come from? $661. Another, what, $837. I found $837, $661.20. And I found, let me see. Where, oh, another one. $980.76. Where is this analyst? And does $980.73 respect the 12-month floor? Huh? And then I give you the inside the imprints, $1,339. And then you got $4,881, 38% more. So I'm breaking down how they, as the years go, they tax you through the roof. So in 2021, $3,989. 2022, $3,822. In 2023, $3,542. But no tax was dispersed in 2024, the year the escrow was waived. But the net tax disbursement, bro, was $827,2025. It was $4,881. 37.8% above the 2023 figure, and posted with a manual code rather than the automated code used for every prior tax disbursement. Oh, the goddamn audit is a goddamn...
You're rocking with the best. You're rocking with the best.
Down to the penny, the year. We're gonna analyze. Okay, the year they did this year. They did it this year. Why did it jump this year? That's a 37% increase. Hold on. So you got all these disbursements. You jumping up to 2024, but there ain't no disbursements for that year. What's going on? See, the audit, it opens the avenue for claims that you didn't even contemplate. And no caps, that's something that you are going to see yourself. Claims that you didn't even like damn. You got started on it, but with the numbers, we just drove it home. And yes, the actual thing from this lawyer gave you about that little funding document, that was everything that you sent me. Was I use everything that you sent me. I know you sent it to me again, but I already had it, so I already incorporated that into it anyway. So when that time you sent it to me, it was already incorporated. Because I said, I know he sent me something else. He did ask me a question about something. I said, let me run the numbers on this too. Your numbers are they're all over the place. And one common theme is they're unexplained for. I can show you another 4 people. I could pull up another 4. It's all the same thing, unexplained numbers. This is why I call it the hidden ledger, aka the hidden figures. And they are very tricky. They'll sprinkle an extra $50 here, an extra $1,000 there, extra $75 there over some escrow advances or corporate advances. They'll sprinkle the reimbursement fees that they could charge it back to you. That's from another document that wasn't authorized by the note, but they'll slide it up into there. So when I break the numbers down, it's always this $500 here, $700 here, $900 here, $1,000 there. That's unexplained. So since they can't explain it, it's being authorized by the note, I go back to the source that can explain it. I don't ever show people the source because it was given to me privately. But I word it and put it in a way where now we make them explain the source. It's not on the note. It's not there. So that's when you take, please don't attach the ledger as evidence. Yeah, you know you don't do that. If you've gotten one, if you need help with integrating the ledger into your drafting complaint, just reach out. Just reach out. We'll put it together. Just reach out. Even if you need hey, listen, man, I just need what should I put here? What statute? How would this apply? We'll do that. You could type the shit up yourself. You could do this shit, yeah, but we'll at least help you integrate it perfectly, masterfully, integrated to the point where it's forcing them to explain the hidden figures. And remember, once one set of number is off and they try to supplement those numbers, it's just like accounting. Once the numbers is off, those off numbers has to be reconciled before you update it. So let's say they try to update the figures with an updated statement. The numbers that were already off first don't get reconciled by the new numbers, because all you do is take the different I ain't gonna say all that, but the new numbers, it's not gonna reconcile the old numbers. It's just gonna compound the claims new. It's been stopping these people in their tracks. Wanna know why? Told you already. We know that the numbers don't ever come from the contract. The numbers come from the corporate finance side. They can't reconcile corporate finance lends back to the contract because the contract don't authorize the corporate finance. So they're stuck in limbo. I have to explain the corporate finance side, which is going to hit to my point that you're not in the consumer transaction the way you think it is. You're in a multi-tier, multi-level corporate finance transaction. All your charges, all your fees comes from the corporate finance side. Your APR finance, corporate finance side. The interest you pay has nothing to do with the contract, has nothing to do with the loose loan and forbearance of money. Remember, the 5 lenses of the contract, the corporate finance lens, they're not looking at it as a consumer repayment of a traditional loan. That's not how they look at it. So we're bringing the 5 lenses of the contract to you. Please join the Patreon. Get in the Patreon. If you're not in the Patreon, join the Patreon. You are not in the Patreon, join the Patreon. Get the hidden ledger. Get the reports. Get your lawsuits or whatever you're filing. Get it reviewed. Let us apply 5 different angles, 5 different lenses to your filing. Let us apply the 5 different, let's apply the 5 lenses to you. Let us look at your contract 5 different ways. Maybe it'll strengthen your consumer claim. Maybe it'll strengthen your what's the arguments that they raise? Furnishing inaccurate amounts due, inaccurate payments due, your consumer claims, and that's what it does. All right, y'all.
Run it up, running band. It's get on my team, they know who I am. They rolling the dice, we win cause we plan. The things that they teach don't know how to stand. I'm a wrist like a stage, they can't glance. You look like you wanna let go of stress. What's up? I thought so. Oh, I am the blueprint, if not, why you copy me, fam? What's up? I thought so. Okay, I cannot help that they copy. Hey, I am the dad, call me Poppy. Yo, they wish they created the set. Yes, they on my D like a jockey. When it comes to the print, I'm the blue. Who? Every complaint, draft is smooth. Supreme Elite team be the ones. Yo, I created my own school. Facts. I came from the trenches. I came from riding them benches. To proving my case with exhibits. My craft is exquisite. I find where they hiding them digits. The cancer that's not in remission. Hey, please pay attention. You can't recreate the 5 lenses. You can't duplicate what is written. You either gonna pay the tuition or pay for assistances. Or pay the mistakes when you case it, dismiss them. I come with everything that's under the kitchen sink. I haven't slept in a week. They scared while I'm willing to compete. These scammers are devils and I keep them under my feet. Hey, they saying they win, I never take their prescription. They never coming from the plaintiff's position. I am the blueprint, blatant admission. Check it, when I talk classes in session, professionals, even the tacos respect it. Show me a win, that's not a rejection. Tell me the truth without all the stretching. These gurus are boring and it's stretching. These students are dumb, desperate depression. Set you, yeah, I'm done with this lesson. Came from the streets, still I'm a step up. Run it up, running bands. They scared of my team, they know who I am. They rolling the dice, we win cause we plan. On the things that they teach, don't know how to stand. On my wrist like a stage, they can't glance. You look like you wanna let go of stress. I thought so. Oh, I am the blueprint, if not, why you copy me, fam? What's up? I thought so. Okay. New culture, he running this shit. Like he came with a gun in this bitch. And he double up wins back to back. Like he ain't even done with this shit. Come to court like a dog off the leash. Dismantle the evidence, break down their claims, and he start from the top of the sheet right here. Whenever he taught, they retreat. He's a lead with his team, they supreme. He brings reality out of drink. Okay, they can't help but watch from the clouds. They trying the words and the memes. Alibi with the feds. You fuck with alibi, you be in the feds. Lawful lovey, still a rookie. Can't stand on the shit that they saying. Hey, he beat his case, he beat CAC to submission, stipulated the disposition. Westlake, he tried to give a break. Attention they didn't wanna pay. Made them max sit, they on case. Get the fuck out his face. The new culture ain't wanna play. The new culture running this shit. The new culture with debate. Anyone who think they running this shit, he take your docs and expose that shit. Gon' be acting like you never sold that shit. They copy his drip like he sold that shit. Ain't no guessing with him, gotta know that shit. Hey, you gotta know that shit. He be credit acceptance, I be Westlake. Whatever I'm serving, they eat the plate. They don't watch me loud, but they watch from the clouds. They copy my style, but can't figure me out. The 5 mentions I created that you can't duplicate from an AI chat. He thinking things that they can't comprehend and teach what people did not know exist. Run it up, running band. They scared of my team, they know who I am. They rolling the dice, we win cause we plan. The things that they teach don't know how to stand. On my wrist like a stage, they can't glance. You look like you wanna let go of stress. I thought so. Okay, I'm the blueprint, if not, why you copy me, fam? I thought so. Okay. I thought so. Okay. I thought so. Okay.
You're rocking with the best. You're rocking with the best.
Another firm has started their investigation, but then you have my lawsuit. Now, why does my lawsuit so damaging to credit acceptance. It puts them between a rock and a hard spot, because any other legal case or legal action that they file, they always appear and defend it. They've been getting sued forever. This ain't nothing new to them. They know how it goes. They don't ever not show up and make an appearance or defend. They don't ever not do it. They don't ever not do it. Even with the government, they made an appearance. Even with the government. So it's not just about, I will just tap out. No. The problem with credit acceptance is, if it was just my case individually, I believe they would have responded. But the way I argue my complaint, they can't even respond to my complaint without opening themselves up on the other, especially the class action. Because I wedged it together so much that you can't even separate consumer claims to their internal operation. I bridged them two together, so they can't deny their operations with me, because the Rosa Law Firm is watching my case. It's going to be an automatic loss from there. They can't admit what I'm saying is true to their internal operations, because it's going to open them up to exposures over there. They can't say no here, because it's an automatic yes over there. They can't say what I'm saying is not true, because they're really going to get hit for lying, falsifying regulatory documents on that end. So they are stuck